Hi, I'm Jason Sullivan of Rathbone Group, and this is on subrogation. This video is the first in a three-part series where we're going to discuss liability or potential liability on individuals who witness or respond to emergency situations. We'll stick with a common fact pattern. You have an insured and their house burns down. Each of the scenarios is going to take a look at three different situations which may happen and what subrogation potential there may be. In this video, we're going to look at bystander responsibility. If your insured's home is on fire and somebody's walking by the street and they see smoke coming out the windows and they see fire and flames, what obligation or responsibility does that person have? In the majority of states, there's no obligation or responsibility for that bystander to do anything at all. There are an increasing number of newspaper stories and reports about individuals who see some kind of crime or peril or danger or something happening and they stand by. They don't do anything, or they pull out their phones and video it or live stream it and just let it go on by. There's been some outrage in those situations as, how come people didn't act? They could have prevented some harm or some injury if they would have just done something and not just stood there. At least call 911. But in the majority of states, there's no responsibility to do so. In some states, Minnesota, Vermont, and Rhode Island, for instance, they do have a responsibility for a bystander to contact authorities if someone is in grave physical harm. So if you see someone who is laying in the middle of the road, for instance, you as a bystander have some duty to try and assist that person, whether to be calling the police or to take some other action. If you just move on by or record and see the outcome of it, you may have some responsibility for that. In other states, including Ohio where I'm located, there is a responsibility to notify the police if the person or bystander suspects that there's an ongoing crime. Now, there are a handful of states that have this rule that a bystander or a witness must report a crime, but there are some caveats. One, that the crime is going to result in serious physical injury to the person, or it has to reach the level of crime such as a felony. In those cases, if you meet those specific requirements in the state, a bystander or a witness has a duty to reach out to law enforcement to try and stop the situation. In all these cases, the bystander doesn't have to put themselves in peril or jeopardy. They just need to take an action to notify the police, which they should be able to do without hurting or putting their own safety at risk. In the vast majority of states, there's no obligation at all. Now, if a bystander does take action, many states have Good Samaritan laws. And a Good Samaritan law basically says that somebody who comes to the rescue or aid of someone else can't be found liable for any negligence that somebody may pursue against them. So let's take our house burning case. A bystander sees a house on fire. They bust through the front door, they see a fire on the stove, and they pour water on it. Now it's a grease fire, and if you have any fire safety experience at all, you know you don't put water on a grease fire because that just causes the fire to spread. Well, it could be negligence for a bystander to run into a house and pour water onto a grease fire, thereby spreading the fire and making it worse. Most states' Good Samaritan laws are going to protect the individual. It's negligence on the bystander's part who's now taking action, and as a public policy matter, we don't want to disincentivize people to help try and prevent harm, even if they do so in a negligent manner and it makes things worse. So, if you are a bystander, you can't act recklessly, and certainly if you intentionally increase the harm, that's going to be a problem for you. But if just by your negligence in trying to help you cause some harm, most Good Samaritan laws are going to protect you. If you have caused the harm, for instance, if your neighbor is an arsonist and they set your house on fire, and then they claim that they were trying to then put it out and do so negligently because they intentionally created the harm, they can still be held responsible. So the Good Samaritan law is not going to follow or protect those individuals who intentionally cause harm. So, as a recap, bystanders usually don't have a duty to come to the aid to prevent some injury or harm to someone else's property. In a few states they do if there's serious bodily injury at risk, or if that person has reason to know that there's a crime being committed. In our scenario, again, where it's just a house burning and no knowledge that someone started it intentionally and we have an arson issue on our hands, that person in those states where crime is the rule that creates that duty, that person's not going to have any obligation to come to the assistance or to try and put out the fire or to even call 911. If you have any questions for us, please email us at video@rathbonegroup.com. Otherwise, subscribe to our channel and look for more information on subrogation. For Rathbone Group, that's the long and short of it.